And as we make the transition, I wanted to welcome our second panel, Representative Harriet Hagman and Ranking Member Jerry Nadler from the Committee on Judiciary, and Chairman James Comer and Ranking Member Jamie Raskin, who may join us in progress. So Representative Hageman, as you're ready, we welcome your testimony. Sure. If the gentlelady will suspend for one moment, I see the chairman of the Chairman Raskin. I'm sorry, Chairman Comer, if you would join us at the table. And Ranking Member Raskin will join us when he is able. I apologize, Representative Hageman. Please continue with your testimony.
Very important issue. This resolution upholds the institutional power of the House by recommending that the House find Attorney General Merrick Garland in contempt of Congress for failing to comply with the Judiciary Committee's subpoena. It's very simple. Attorney General Garland holds information vital to the committee's legislative oversight and the House's impeachment inquiry. Attorney General Garland has refused to comply with the committee's subpoena, and only belatedly did President Biden invoke an invalid executive privilege assertion over the audio recordings. Special Counsel Robert Hur stated on page 1 of his report, quote, "Our investigation uncovered evidence that President Biden willfully retained and disclosed classified materials after his vice presidency when he was a private citizen," end quote. Joe Biden not only kept information he wasn't allowed to keep, he also shared it with people who weren't allowed to see it. He shared that information with his ghostwriter. Special Counsel Hur stated on page 231 of his report that President Biden, quote, "had strong motivations to ignore the proper procedures for safeguarding the classified information in his notebooks. He decided months before leaving office to write a book," end quote. A book for which Joe Biden received an $8 million advance. But all this, and Special Counsel Hur declined to prosecute President Biden because Joe Biden is, quote, "a sympathetic, well-meaning, elderly man with a poor memory," end quote. Following the release of Special Counsel Hur's report, both the Judiciary and the Oversight Committees issued subpoenas requiring Attorney General Garland to turn over the transcripts and audio recordings of Special Counsel Hur's interview with President Biden and his ghostwriter, among other information. To date, Attorney General Garland has failed and refused to produce these audio recordings. To determine whether Special Counsel Hur appropriately carried out justice by not prosecuting the president, the recordings are necessary. The transcripts alone are not sufficient evidence of the state of the president's memory. This executive branch has a history of changing transcripts. In late April, during a public speech, President Biden read a teleprompter instruction to pause. He stated, quote, "Imagine what we could do next, 4 more years, pause," end quote. But when the White House put out the transcript, it didn't include the word pause. In that case, and in this case as well, the video and audio recording is the best evidence of the words that President Biden actually spoke. The department's refusal to produce the audio recordings of Special Counsel Hur's interviews with President Biden amounts to a demand that the committee trust the department created and produced interview transcripts are accurate and complete. Following the issuance of the subpoenas, and despite repeated follow-up from the committee, the department continued to withhold the audio recordings of those interviews without providing any constitutional or legal basis to do so. And then hours before the committee was set to meet and consider this contempt resolution, the department notified the committee that President Biden had asserted, at the Attorney General's urging, no less, executive privilege over the audio recordings. This belated assertion of executive privilege fails for numerous reasons. First, President Biden has already waived any potential assertion of executive privilege over the information discussed in his interviews with Special Counsel Hur by releasing the transcripts of those interviews to the media. Similarly, during Watergate, a federal district court held that President Nixon had waived any claim of executive privilege over certain audio recordings of his conversations because he had already published transcripts of those conversations. Second, President Biden's assertion of privilege is not valid because it is more than 2 months late. Any privilege should have been asserted by March 7, 2024, the subpoena return date. Third, President Biden has not set forth any valid reasons for invoking executive privilege. During these interviews, he was not receiving advice regarding the execution of his presidential responsibilities. Rather, he was sitting for an interview with a special counsel investigating whether he mishandled classified documents while he was a private citizen. Fourth, the law enforcement concerns set forth by the executive branch lack merit and are outweighed by the committee's need for the audio recordings. There is just no reason to believe that individuals will be substantially less likely to cooperate with department investigations of both an interview transcript and audio recordings are produced to Congress, as opposed to just the interview transcript. The department has a legal obligation to turn over the requested materials pursuant to the subpoena. Attorney General Garland's willful refusal to comply with our subpoena constitutes contempt of Congress. Our oversight and impeachment responsibilities are too important to allow Attorney General Garland to willfully and unlawfully disregard our lawful subpoena. With that, I yield back.
Sure. Thanks, gentlelady. The gentleman from New York, Ranking Member Nadler, is recognized.
Thank you. Mr. Chairman, the Judiciary Committee under Republican control has spent the last 18 months and $20 million taxpayer dollars in a desperate search to find something, anything, that they can use to damage President Biden and to protect Donald Trump. Other committees have gotten into the act as well, spending untold taxpayer money not to benefit the American people, not to feed hungry children, not to address our housing crisis, not to improve our health care system, but on a single-minded quest to follow every right-wing conspiracy theory in the vain hope that it might lead to some evidence of wrongdoing. And what exactly have they delivered to the American people on their investment? Nothing. No evidence that the conspiracies are true, no indictments, no impeachment, no wins of any significance. And the Republican leadership knows that if they don't come up with something to show for the millions of dollars they have spent, the MAGA political base may stay home next November. So they are scrambling in a desperate attempt to look like they have accomplished something. They were fervently hoping that Special Counsel Hur would indict President Biden for mishandling classified documents so that they could attack President Biden and misdirect the American people away from Donald Trump's treacherous handling of classified information. But the special counsel cleared Mr. Biden of wrongdoing for reasons that have nothing to do with Mr. Hur's gratuitous and widely contradicted comments about the president's memory. So what do our Republican friends do when an investigation turns up short? Simply put, they engage in fantasy. That's what they are doing here today. Unable to come up with any wrongdoing by the president, they have now trained their sights on the Attorney General. They accuse him of withholding key evidence, but the Attorney General has substantially complied with their every request. Sometimes he has been too responsive, in my opinion, given the obvious bad faith of the MAGA majority. DOJ has produced 92,000 pages of documents since Republicans took control of the House last year, and has made dozens of witnesses available for interviews, hearings, and briefings. That's more pages of documents and more witnesses than the Trump Justice Department produced to Congress in 4 years. Just last week, the Attorney General himself spent more than 5 hours testifying before the Judiciary Committee. With respect to the subpoena at issue in this contempt resolution, the Department turned over all the information Republicans asked for. There has been no obstruction, only cooperation. In reality, the Attorney General and DOJ have been fully responsive to Congress in every way that might be material to their long-dead impeachment inquiry. All that remains are audio files for which the President has asserted executive privilege. In a letter to Chairman Jordan and Comer, the Department of Justice noted that producing the audio recordings would, quote, raise an unacceptable risk of undermining the department's ability to conduct high-profile criminal investigations, in particular, investigations where the voluntary cooperation of the White House officials is exceedingly important, close quote. The chairman claimed that they need these records to understand the pauses, pace, and tone of the conversation. This is absurd and clearly pretextual, and in any event, it does not outweigh the substantial concerns expressed by the President and the Department. Moreover, with respect to the recording at issue in this report, a complete certified transcript has already been provided to both committees. And no credible allegation has been made that these transcripts have been altered in any material way. The only thing that has not been produced is the recording itself, something that in the wrong hands, specifically in Mr. Jordan's hands, can be easily manipulated. This is not an idle concern. Last year, a witness testifying in a closed-door deposition told us that she was the victim of a manipulated video amplified by Republicans on the Judiciary Committee and that it contributed to a flood of death threats against her. Nina Jankowicz told us this about her deposition in April 2023. This isn't really about a policy disagreement with the DOJ. This is about feeding the MAGA base after 18 months of investigations that have produced failure after failure. Like most of the bills House Republicans have pushed on purely partisan lines, this contempt resolution will do very little, other than smear the reputation of Merrick Garland, who will remain a good and decent public servant no matter what Republicans say about him today. This resolution may boost Donald Trump's spirits before his sentencing for his conviction on 34 felonies, but it will certainly not convince the Department of Justice to produce the one remaining file in question. Like the broader impeachment effort before it, this contempt resolution will have been a partisan stunt, destined to fail from the very start. The American people actually need us to do important work. I'm tired of these games, and so are the American people. I urge my colleagues to oppose this measure, and I'd be very happy to answer any questions you may have. I yield back.
Gentleman yields back. Chair thanks the gentleman. Chairman Comer, you're recognized for restating your wish.
Thank you very much, Chairman Burgess and members of the House Rules Committee. The Oversight Committee's February 27th subpoena required the Department of Justice to produce audio recordings of President Biden's interview with Special Counsel Robert Hur regarding the President's mishandling and improper disclosure of classified materials. The Department failed to produce them. The Oversight Committee held a markup to consider a report holding Attorney General Merrick Garland in contempt of Congress and favorably passed that report. This is not a complicated matter. The executive branch and its agencies, including the Department of Justice, are not above Congress's right to oversee those agencies. We, as members of the House of Representatives, have a duty to ensure congressional subpoenas are fully complied with by those who receive them, people, companies, and particularly the federal government. My colleagues on the other side of the aisle constantly talk about the threats to our institutions, but then they turn around and defend the DOJ's noncompliance with a duly authorized subpoena showing their partisanship. If my colleagues will not defend the institution of Congress, the institution they are a part of, how can we listen with a straight face when they talk about the sanctity of our other institutions? The President has asserted executive privilege over these audio recordings. Legal scholars find this assertion bizarre and meritless. The President has waived any executive privilege over these audio recordings by releasing a transcript of the entire interview to the public. When the transcript was released, President Biden's own White House spokesperson claimed, quote, in keeping with his commitment to cooperation and transparency throughout this investigation, the President declined to assert privilege over any portion of the report, end quote. My question to the White House is, what happened to cooperation and transparency? What reason does the White House have to inappropriately assert executive privilege now? The White House has shown it is willing to alter transcripts to protect Joe Biden's image. It is insufficient to simply take the Justice Department at its word that the transcripts have not been altered. The Department of Justice does not get to decide how to comply with the subpoena, just as the people who receive subpoenas from DOJ cannot determine how they will comply. The Oversight Committee has conducted its own investigation into President Biden's mishandling of classified materials, and its findings contradict key portions of the White House's and President Biden's personal attorney's official narrative. Months of investigating by the Oversight Committee have revealed the White House has attempted to withhold the truth from the American people. As I stated in our markup, the Oversight Committee's timeline begins well before the White House's narrative that President Biden's private lawyers just stumbled upon classified materials in November 2022 at the Penn Biden Center. By May 24, 2022, 6 months before the White House's story began, the White House counsel, Dana Remus, contacted a Biden former employee to retrieve President Biden's materials from the Penn Biden Center. She then traveled there herself to pick boxes up. Again, as I stated previously, and have not yet received an answer, why would the most senior lawyer at the White House be going to pack up an office that was supposed to only have pictures and personal documents in it? Why were President Biden's personal lawyers visiting the Penn Biden Center days before the, quote, discovery of classified materials if they thought they were just picking up pictures and letters? Why were they calling FedEx to pick up boxes and a White House employee was leaving with boxes before the November 2nd discovery? These are questions I continue to ask because so far none have been provided. Not by Special Counsel Hur, not by the White House, not by the Department of Justice, and certainly not by President Biden. If the Attorney General chooses to defy Congress and not produce the audio recordings, he must face the consequences of his actions. The path before us is clear, and the Oversight Committee recommends the Attorney General be found in contempt of Congress. Neither he nor President Biden are above Congress's oversight. Thank you, Mr. Chairman. I yield back.
Chair thanks the gentleman. Gentleman yields back. Chair now recognizes, welcomes back to the Rules Committee, the ranking member of the Oversight Committee, Mr. Raskin.
Thank you very kindly, Chairman Burgess. It's a delight to be with you and with Chairman McGovern and with my old buddies on the Rules Committee. There's plainly no basis for holding the Attorney General of the United States, Merrick Garland, in contempt, unless we're going to start holding people in contempt for complying with the committee's demands. This is actually the third witness who has faithfully cooperated with the Oversight Committee that the chairman has now threatened with contempt, the first being FBI Director Christopher Wray, the second being Hunter Biden. So this is the third time, and again, it makes no sense. Attorney General Garland and the Biden administration have consistently cooperated with the demands made by Chairman Comer and Jordan for information relating to Special Counsel Hur's review of President Biden. The Attorney General released the Special Counsel's report on President Biden in full. The DOJ made Special Counsel Hur available for multiple hours of testimony and examination before the Judiciary Committee, and he answered all of our questions. The DOJ also provided correspondence between the Department of Justice and the President's lawyers, documents referenced in the Hur report's appendix, and the transcript of the Special Counsel's interview with the President's ghostwriter, Mark Zwanitzer, in complete detail in response to the chair's requests. And the Attorney General provided us the full transcript of President Biden's voluntary 5-hour interview with the Special Counsel, all 250-plus pages of it. The Department of Justice and the administration have given us all the information we asked for. Now, Chairman Comer and Chairman Jordan, who was subpoenaed by the January 6th Select Committee and never rendered a single document to it or spent 1 minute testifying before it, respond by seeking to hold the Attorney General of the United States of America in contempt based on preposterous claims of obstruction. Like their slapstick impeachment drives against President Biden and Secretary Mayorkas, this new tragic comic contempt drive is doomed because it's wrong on the facts, it's wrong on the law, and it's wrong about who the real culprit is. The motion before you today projects the lawless conduct that Republicans regularly defended when Donald Trump was president onto an attorney general who has devoted his entire career and life to defending the rule of law. Unlike the Biden administration, which has cooperated fully here, the Trump administration refused to comply in any way with the 2019 impeachment inquiry into Trump's shakedown of Ukrainian President Zelensky. Trump ordered administration officials who were material witnesses not to cooperate with requests for interviews. In total, 12 federal officials absolutely refused to testify before Congress, 10 of whom blatantly defied congressional subpoenas. And this was just a part of a larger pattern of obstruction in the Trump administration, which refused to cooperate with more than 100 committee investigations and inquiries on a range of subjects, something that did not seem to trouble my colleagues at all. By contrast, Attorney General Garland and the Department of Justice have cooperated substantially, materially, and fully with every single one of the requests bombarding his office in this bad faith, madcap, endless impeachment investigation. In fact, every member of Congress, and indeed every American, can today go online and read President Biden's answers to every single question posed to him by Special Counsel Robert Hur. And we can access it because under Attorney General Garland, the DOJ provided the full and complete, I repeat, full and complete transcript of the presidential interview to Chairman James Comer and Jim Jordan. Meantime, the good chairman of the Oversight Committee has not released the transcripts of any of the committee's interviews regarding the classified document. None at all. But Republicans have responded to Garland's striking good faith cooperation by trying to hold the Attorney General in contempt because they say they do not want to read the president's answers in the interview. They want to listen to the book on tape. In a last-ditch attempt to blame a cabinet member for the spectacular failure of their laughingstock impeachment drive, they have contrived an allegation that Garland has impeded their inquiry by preventing them from hearing rather than reading President Biden's interview with the special counsel. The claim falsely implies that reading the words written out across 250 transcript pages isn't enough, and that hearing them would somehow change the content of the president's interview or the meaning of his answers and suddenly reveal the holy grail of the 118th Congress, evidence of the still unnamed and unidentified impeachable offense they've been spending millions of taxpayer dollars looking for. In fact, they want to pour over 5 hours of President Biden's taped interview to search not for an impeachable offense, because they know that doesn't exist at this point, but for a verbal mistake, like a mispronounced name that they can turn into a political TV attack ad in the presidential campaign. And yet, even after weaponizing House committees for this nakedly political pursuit, after amassing nearly 4 million pages of documents and 80 hours of testimony from 19 different witnesses, and even with their robotic diligence in cherry-picking facts, distorting evidence, wasting taxpayer money, and echoing blatant Russian disinformation, Republicans still haven't found any evidence that President Biden committed a crime, much less an impeachable offense. Not a single morsel of evidence. The cupboard is empty. Last week, Republicans surrendered what was left of their floundering investigation, making half-hearted, last-ditch criminal referrals of the president's family members to the DOJ for some weak tea gotcha accusations. Most importantly, these referrals did not identify any crime, any misdemeanor, or any impeachable offense that President Biden even allegedly committed. Not one. Now, in the wake of the collapse of this effort, they want America to believe that their 17-month impeachment quest failed, not because they had no relevant evidence of any identifiable impeachable offense, but because Attorney General Garland did not produce an audio tape of a book whose words they already possess and all of America can read. The Attorney General has given Chairman Comer all the information he has sought, and our do-nothing Congress is now finally about to do something, but it's something ridiculous and absurd. They're about to hold the Attorney General of the United States of America in contempt for actually complying with the demands of Congress. I urge the committee to reject this request for a rule to bring a contempt resolution against the Attorney General of the United States to the floor of the House of Representatives. Thank you, Mr. Chairman. I yield back.
Thanks, gentlemen, and thank all of our witnesses for their thoughtful testimony today. Let me just ask a question. Representative Hageman and Chairman Comer, do you have any confidence that the actual interviews, the taped interviews, still exist? Or are those likely to have disappeared somewhere?
I would assume they still exist. They should.
I know they should. But there's obviously so much energy being expended to prevent the public from hearing these. And you have to ask yourself, why is there so much energy being, clearly it's not executive privilege. I mean, that was waived with the production of the transcribed interviews. If there's this much energy being placed to put a wall between the American public and the substance of these, or the transcripts of these, I'm sorry, the audio of these interviews, clearly there's something that they desperately want to prevent from going to the hands of the American people.
Could I answer the question?
Mr. Burgess, I would say something in response to that. If they don't exist, I would say that someone has actually destroyed evidence. And that would be a very serious concern if someone actually did something with those audio tapes. I also think it's very important that we clarify some of the testimony that has been provided, which is there is the repeated claim that the transcript and the audio are identical, and that's not true. And in fact, it has been admitted over the last 2 weeks that there are differences between the transcript and the audio that they will not release. And it's one of the reasons why we absolutely have to have that audio, because they are not identical, and anyone who claims to the contrary is being disingenuous.
I agree, Chairman Comer?
Yeah, and I agree with everything she said. And another point that my colleagues to my left forgot to mention when they said that it's the House Republicans that want these audio tapes. The Associated Press, CNN, ABC, CBS, NBC, Reuters, Bloomberg, and the Washington Post, as well as other mainstream media outlets, have all sued to get the recordings as well. So it's, the American people want to see those audio recordings in addition to the investigators in the House of Representatives. So I think that's a very important point to note.
I'm sorry, Ranking Member Nadler, you had wanted to say something?
Yes, I want to say a few things. The basic reason the department doesn't want, I think, the basic reason the department doesn't want to release the transcript is because they have good reason to believe that the Republican leadership on the Judiciary Committee would alter the transcript, as they did with the Nina Jankowicz matter. She told us that in her deposition of April 2023, the Judiciary Committee altered, by cutting and pasting, altered the meaning of what she had said. And I assume that's the reason that the Justice Department doesn't want to release the transcript. I would also point out that, you know, the Republicans are claiming that the DOJ waived the ability to claim executive privilege by producing the written transcripts. Legally, that's simply wrong. Audio recordings have distinct features and law enforcement uses. Release of audio would have a unique chilling effect on future DOJ investigations. Also, finding a waiver here would punish DOJ for cooperating with Congress. And I don't think we want to punish the DOJ for cooperating with Congress. I would also point out, contrary to some of the insinuations we heard from my two colleagues to my left, to my right rather, I'm sorry, God forbid to my left, my two colleagues to my right, that Mr. Herr, who was a Republican, who used to work for Bill Barr, conducted a thorough investigation and found there was no basis for charging the president with improper retention or mishandling of classified documents, whereas, of course, the special prosecutor has indicted former President, or got a grand jury to indict former President Trump for mishandling classified documents, and he will have to go to trial. So it's a world of difference, and we should not be...
I'm going to interrupt you there. It is a world of difference because President Trump was president. These documents were procured when the Vice President Biden they were under his control. He did not have the same ability as the president to declassify and move these things.
I'm not going to debate that with you. I will simply point out that the special prosecutor, Mr. Herr, found no basis for indicting Mr. Biden, while the special prosecutor, Mr. Smith, persuaded the grand jury to indict Mr. Trump.
By your own admission, Mr. Nadler, you said that Mr. Herr's comments when he related the status of this interview was that the president seemed well-meaning but confused. Now, I think, and you said yourself, you characterized that. I think the American people deserve the opportunity to be able to hear that for themselves. People are smart. They can make that discernment on their own.
His report made very clear that there were multiple reasons for not indicting Mr. Biden. His gratuitous comment about Mr. Biden's...
I'm sorry, I'm going to interrupt you. I'll give you a chance to respond, but you're characterizing that as gratuitous is in and of itself gratuitous. I mean, you do not get to have that.
You can judge that. I don't think it's gratuitous. His comment was gratuitous because, if you read his report, that's not why the president was not indicted. There are ample reasons given in the report for not indicting the president. And given that, not including that, and given that fact, to make that observation was gratuitous.
Well, why not then clear the air and make the actual audio of the interview available? Let the American people be the deciders here.
Because
why hide that from them?
Because
people are sensitive because they were told that, say, a certain laptop was Russian disinformation, and 51 members of the intelligence community signed a letter to that effect, and then it turns out, well, maybe it was not.
Because the chairman of the Judiciary Committee has already been caught altering...
May I respond?
No, not until I finish. Has been caught altering verbal, electronic transcripts in the case of Nina Jankowicz. And we have every reason to believe, or let me retract that. Yeah. We have no reason to believe that he wouldn't do so again.
Yeah.
If I may respond.
Please, I wish you would.
That is absolutely untrue. Neither Jim Jordan nor anybody on the Judiciary Committee made any changes to Nina Jankowicz's interview transcript. That's absolutely a false statement. There's one other point that I think needs to be clarified, which is that Special Counsel Robert Hur stated on page 1 of his report, our investigation uncovered evidence that President Biden willfully retained and disclosed classified materials after his vice presidency when he was a vice president. The reason that he recommended against prosecuting President Biden was not a gratuitous statement. It was the reason as to why he refused to recommend prosecution, and it was that because Joe Biden is a, quote, sympathetic, well-meaning elderly man with a poor memory, Mr. Hur was concerned that a jury would not be willing to convict. Anyone who wants to see what Mr. Hur actually found and his explanation of what he did, you can go and you can watch the hearing before the Judiciary Committee. But one thing is very clear, and I will go back to it again. The folks on the other side of the aisle keep wanting to say the transcript and the audio are identical. There is no reason why, if you have the transcript, you're entitled to the audio. As a long-practicing attorney, they are not the same thing. The audio is the best evidence of what he said, how he said it, the time that it took for him to say it, and in what ways they may have altered that transcript. The moment that they released the transcript and said, this is the interview, they waived their ability to claim any kind of a privilege, and they don't have a legally valid privilege in addition to that. And it's for that reason that we believe that Merrick Garland needs to be held in contempt of Congress.
I will agree with her.
Gentlemen will suspend. I firmly believe that the American people are entitled to hear this, and I'm grateful that you brought this today. I'll give you a chance to respond, Mr. Nadler, but then we need to move on to Mr.
I will agree with Ms. Hageman that there is no evidence that the transcript was altered whatsoever. The transcript wasn't altered. But in Ms. Hageman, I'm sorry, Ms. Jankowicz's case, the transcript wasn't altered, the video was altered. Yeah. And that's what we're concerned about.
We're not arguing the Jankowicz case, we're arguing...
No, but if the Judiciary Committee
the American people deserve the ability to see that and make this decision on their own. They are sick and tired of being lied to by agencies.
If the Judiciary Committee was dishonest enough, the leadership, to manipulate the video in the Jankowicz matter, it is dishonest enough to manipulate the video in this matter, and that is a good reason to withhold it.
Ranking Member Raskin, Ranking Member Nadler, Chairman Comer, and we're missing a chairman here. Mr. Jordan, I think, sent a substitute, which is unfortunate because I I would have liked to have asked Chairman Jordan about his noncompliance with the congressional subpoena, but I guess maybe he was too afraid to come or didn't want to have to deal with that question. I got to be honest with you. I mean, what the American people are sick of is how pathetic this House of Representatives have become. So let's just, I mean, this is a distraction from the fact that the Republican nominee for president is a convicted felon. That's what this is all about. Republicans have weaponized committee after committee to the point that it is doing great damage to this institution. Democrats, Republicans, and independents are looking at the way this House is being run, and they think it's pathetic. You know, we are here because Republicans are falsely claiming that the Attorney General is playing politics with the Justice Department. They are irresponsibly attacking the DOJ, making absurd claims that it is being weaponized. These contempt resolutions represent more of those attacks. My Republican friends have gone on and on about how Democrats have weaponized the DOJ, but their conspiracy theories crumbled this morning when Hunter Biden, the son of the president, was found guilty in a federal court on 3 gun-related charges. When Donald Trump was convicted, we saw an immediate reaction from Republican leaders. It was like within seconds that this trial is a sham, the judge is corrupt, the jury is rigged, and the contrast today is just staggering. Apparently, when a Republican is convicted, it's weaponization. But when a Democrat is convicted, the president's son no less, that's justice. I mean, give me a break. Hunter Biden was found guilty by a jury of his peers, just like Donald Trump, because this is our justice system at work. The divide here is stunning, and it's a great reminder that one political party remains committed to the rule of law and the other doesn't. It's that simple. Did Hunter Biden walk out of the courthouse this morning and slam the judge or the prosecutors? Did he claim some vast conspiracy to weaponize the legal system against him? No, he did not. In a statement on the verdict, President Biden said, and I quote, "I will accept the outcome of this case and will continue to respect the judicial process," end quote. Now I ask, after the verdict this morning, how can any Republican in their right mind argue that the Biden administration is weaponizing the DOJ to hurt Republicans and to help Democrats? They just convicted the president's own son, to say nothing of the fact that the Department of Justice is currently trying a Democratic senator and has indicted a Democratic member of this House. I mean, do Republicans still believe that President Biden is weaponizing the justice system? Because if he is, he's sure doing a lousy job. And as usual, the only Trump derangement syndrome going on around here is on the other side of the aisle. I mean, people are saying that Biden orchestrated the conviction of his own son in order to justify the criminal charges against Trump. That is how you think when you are in a cult. So here's the bottom line. Republicans just can't wrap their heads around the idea that their presidential candidate, your presumptive nominee, is a convicted felon. That is not the result of a sham process or some vast conspiracy by the Biden administration. That is the result of the truth. And these attacks on our justice system have to come to a stop. They are dangerous, they are irresponsible, they are nothing but false conspiracy theories being pushed to try and excuse the actions of the former president, and they are made even more absurd by the outcome of the trial this morning in Delaware. Mr. Raskin, for the record, can you contrast the president and the administration's compliance with this investigation with that of Mr. Jordan's noncompliance with the January 6th investigation?
Yes, will you allow me to comment on what you
Absolutely.
just said
Yeah.
as well, Congressman McGovern, and I'm very grateful to you for pointing this out. Hunter Biden was just convicted of every single count that was brought against him by the U.S. Department of Justice. I've not heard a single Democrat anywhere in the country cry fraud, cry fixed, cry rigged, cry kangaroo court, or any of the many epithets that our colleagues have mobilized against the U.S. Department of Justice and our federal court system, despite the fact that Donald Trump was not even tried in federal court. That was at the state level. And they pretend to support state prosecutors and state judges. But then they attribute it to the federal government and they say rigged, fixed, kangaroo court, and so on. You don't hear a single peep out of any Democrat saying that. Why? We believe in the rule of law. We believe in the justice system, and we stand by it. And you know what? Hunter Biden had every right and benefit that Donald Trump had. He had the right to a presumption of innocence. He had a right to counsel, which he exercised like Donald Trump did. He had a right to a jury of his peers, and he had a right to a unanimous verdict. And in both cases, a jury unanimously found against the defendant on all counts in both cases. And compare and contrast the difference in reaction between the Republicans and the Democrats. The Republicans are attacking our entire system of justice and the rule of law because they don't like the way that one case came out. Whereas the son of the President of the United States is prosecuted, and I don't hear a single Democrat crying foul. Now, both Hunter Biden and Donald Trump can afford themselves of every right of appeal that there is. And we stand by the appellate system. But I think that, it's just outrageous to see the way that our colleagues turn on the rule of law and the system of justice. And it's a profoundly dangerous thing that we witness. Now, you've asked me to contrast, Chairman McGovern, the cooperation and the compliance of Attorney General Garland and the Department of Justice with the non-cooperation of Jim Jordan with the January 6th Select Committee. Well, let's start with this. As I said before, we have gotten substantially and fully and materially everything that this committee has asked for from the Department of Justice and from the Biden administration. Again, that is a striking contrast with the Trump administration. I remember the day when President Trump, when he was in office, said there would be no cooperation with any committees or subcommittees in Congress. And they blocked investigations in more than 100 cases. And specifically with respect to impeachment, which is super dangerous, he did not allow people who were material witnesses, who had relevant factual testimony to render to the impeachment investigation in the first impeachment of Donald Trump to testify. He said they could not testify, and he just shut it down. I did not hear any of my colleagues have a problem with that. And now they're claiming, well, Merrick Garland has only cooperated 99.99% with our committee. We also want the audio tape. It's not enough for us that we can read every word verbatim that is in the transcript. That's not enough for them. They want the audio tape too. I mean, it's like a sick joke that they would go from standing by Donald Trump's horrific obstructionism of congressional power than to trying to hold the Attorney General of the United States in contempt. Now, as for our friend, Chairman Jordan, who I also wish were here today, he wasn't the only one, by the way. There were other members who were subpoenaed by the January 6th committee to give us whatever relevant material information they had about the violent insurrection against our government in order to force Mike Pence to step outside of his constitutional role and simply declare Donald Trump the president and hand him the keys to the presidency. So we didn't have a word of testimony from Scott Perry. We didn't have a word of testimony from Jim Jordan. We didn't have a word of testimony from Andy Biggs. We didn't have a word of testimony from Kevin McCarthy, and we didn't have a word of testimony from Mo Brooks. Nor did we receive a single document from Scott Perry, nor did we receive a single document from Jim Jordan, nor did we receive a single document from Andy Biggs, nor did we receive a single document from Kevin McCarthy. Nor did we receive a single document from Mo Brooks. So there you're talking about 100% noncompliance and obstruction. They want to hold the Attorney General of the United States of America in contempt for 99.99% compliance with what they're saying now and 100% compliance in reality for what it was that the committee asked for.
Yeah, well, I mean, I regret that Chairman Jordan didn't see fit to come and testify today, because I would have liked to have heard his answer to the same question. But I just want to point out for the record that Hunter Biden was found guilty by a jury of his peers in a case prosecuted by a U.S. attorney appointed by President Trump, presided over by a federal judge appointed by President Trump, and investigated by the FBI with the director appointed by President Trump. And you don't hear anybody here talking about complaining about weaponization. And I just, Mr. Chairman, just for the record, would like to read the statement from President Biden in relationship to the verdict today. I quote him: "As I said last week, I am the president, but I am also a dad. Jill and I love our son, and we are so proud of the man he is today. So many families who have had loved ones battle addiction understand the feeling of pride seeing someone you love come out the other side and be so strong and resilient in recovery. As I also said last week, I will accept the outcome of this case and will continue to respect the judicial process as Hunter considers an appeal. Jill and I will always be there for Hunter and the rest of our family with our love and support. Nothing will ever change that, end quote. I think the fact that we are here wasting our time on this garbage is pathetic. I really do. Mr. Raskin, you want to?
You know, if you can engage me in a little thought experiment, what if one of President Trump's children were prosecuted by the U.S. Department of Justice? The entire Republican Party would be in an uproar, demanding that everybody be fired and that the investigation be quashed, especially if it related to exercise of Second Amendment rights. I've not heard any of them rise to the valiant defense of Hunter Biden's Second Amendment rights, but be that as it may, this is the rule of law, and Hunter Biden had every right that was afforded to him under the rule of law, just like Donald Trump did, and they were both convicted, and they both have the right to appeal, but we should all be standing by the rule of law and the court system. And I would love to hear one of my colleagues defend the discrepancy in their reaction to the Trump verdict and the Hunter Biden verdict, if they can.
Yeah, no, I appreciate that. I do want to correct the record. I think one Republican did come to the defense of Hunter Biden in a way. He's a member of this committee, but he's not here right now. That's Thomas Massey. He said Hunter Biden might deserve to be in jail for something, but purchasing a gun is not it. There are millions of marijuana users who own guns in this country, and none of them should be in jail for possessing a firearm against current laws. I don't necessarily always. I don't agree with all that he is saying on that, but the point of the matter is.
Well, look, I think complex questions may be raised on appeal in that case, in any case. And we've got to stand by the system of justice. This is why all of the ethical improprieties and transgressions taking place in the Supreme Court today are so alarming and demoralizing, because you've got, people, billionaire sugar daddies giving millions of dollars to Supreme Court justices, and it undermines everybody's confidence in the rule of law.
And no complaints about that, no concerns about that. I mean, and again, we see what we've been seeing all in this Congress. If Republicans are held accountable for anything, it's a weaponization of the judicial system. If Democrats are held accountable, well, that's justice under the law. I've never ever seen such hypocrisy in my life. And the idea, again, that this is what we're spending our time on, with all that we have to deal with in this country and in the world right now, this is what they think is so important, to get an audio recording of something they already have the transcript of, that this is the world comes to an end if we don't do this. We have to hold the Attorney General in contempt. I mean, give me a break.
I mean, Mr. McGovern, this is an impeachment investigation, and so I have not heard a single colleague explain how there might be something of value to understanding whether there's a high crime and misdemeanor caught in that minuscule space between the written version and the audio version. Not a single one has suggested how a high crime or misdemeanor will emerge in Joe Biden clearing his throat. But I do believe that they might be able to find something with a cut and paste job to turn into a great political attack ad, and nobody has denied that that's the real motivation here.
This is not about high crimes or misdemeanors. This is really about a distraction from the fact that their nominee for president is a convicted felon, period. I thank you for your time. I yield back.
Chair, thanks, the gentleman. Gentleman yields back. Chair, recognize the gentleman from Pennsylvania for questions.
Thanks, Mr. Chairman. I appreciate it. I think that there's only one question that we have to deal with here, and that's one question only. Can the executive branch ignore a subpoena that's not only lawful but valid? That's the one question we're here to decide. Everything else is just a complete distraction. Chairman Comer, would you like to talk about that?
I mean, look, we are the congressional overseers of the executive branch. We have checks and balances in our system. That's the way it was set up. And we have requested these audio recordings. The reason that we stumbled upon President Biden's mishandling of classified documents throughout the Biden influence peddling investigation was there were emails on the laptop that we now know was 100% legitimate because that was the major piece of evidence in the court case that Mr. McGovern cited a dozen times, it seemed like, in the last 30 minutes. There were emails on there that looked like they could potentially be classified documents. And the thing that the investigation has revealed is with the tens of millions of dollars that the Bidens have taken in from our adversaries around the world, there was never a business purpose. You know, they say, the media will say, or the Democrats say, well, in Hunter Biden and Jim Biden, Joe Biden's business dealings. What business was it they were in? Because we haven't ever found a legitimate business. The business, according to at least two people who testified under oath, and that would be Bob Alinsky and Jason Galanis, was they were and three, counting Devin Archer, three former Biden associates said the business was selling the Biden brand. That is called influence peddling. Were any of the classified documents used in the Biden influence peddling scheme? That's the question the Oversight Committee has with respect to the classified documents. And look, I think this is about transparency. Again, and I can't say this enough, it's not just the House Republicans requesting these documents. The Associated Press, CNN, ABC, CBS, NBC, Bloomberg, The Washington Post, that's their people. Their people want it too. The American people want it. Poll after poll shows the American people want transparency. So if there's nothing wrong with the tapes, then just disclose them.
Well, hold on, Mr. Raz. I'm not, you know me, I'm not going to leave you hanging like that. If you want to, go ahead.
Well, but I just wanted to be certain that this constitutes the chairman's endorsement for every petition by the Washington Post and ABC and CBS and CNN to get information. For example, they were asking for all the information that Donald Trump was suppressing for several years and wouldn't give to Congress. Do you agree it should be released because the media wanted it?
What was the question, Mr. Askin?
Well, I'll write it out for you.
Mr. Nadler.
I just want to point out that contrary to what the distinguished chairman said, the House Republicans didn't, quote, stumble on Biden documents. President Biden's personal counsel found the documents at the Penn Biden Center and voluntarily then reported them to the FBI. This cooperation was one reason that Special Counsel Hur declined to indict Biden. And I would contrast this with President Trump, who has hidden and who refused to turn over documents, who necessitated the court to order a search warrant, and who apparently hid documents from the agents executing the search warrant. And that's why the special counsel in the one case, President Trump, has asked the grand jury and got a grand jury to indict him, and in the other case, with President Biden, Mr. Hur declined to ask a grand jury to indict and said there was no crime.
I mean, I get what you're saying, Mr. Nadler. I would just counter with the fact that the decision not to prosecute President Biden was because of the demeanor that was seen on the tape, and there was an assessment.
That is not true. If you read the report, there are many reasons cited for for the decision not to indict, and I mentioned a few of them a moment ago. There are many reasons cited, and I think it's a 231 or 261-page report, and that's why I called the comment about the president's cognitive ability gratuitous, because that was not any one of the major reasons given in the report for declining to indict.
It's my understanding that one of the major reasons was that, and it was in the report, is that President Biden would present to a jury, as I believe the quote was, a well-meaning, I forget the exact word, but basically that he doesn't know what's going on. He doesn't
read
have
the report and see all the other reasons why they declined to indict.
But
in particular, the cooperation that I just mentioned, that it was President Biden's personal counsel who found the documents and at the Penn Biden Center and voluntarily reported them to the FBI.
Okay, but again, it was the demeanor and how he would present to a jury that he'd be sympathetic, that people would think he doesn't have control, mental acuity enough. And
Let me
the fact that
say this.
Hold on, we got to, Mr. Adams, we got
Not
to
to
say
talk-
this. I don't want to get into a
We
debate.
cannot talk over each other. Gentlemen, suspend. The clerk cannot keep up with us when we
I'm sorry.
cross-talk. So let's one at a time.
okay.
Let
Go
me
ahead.
say this. That quote has been used and may have been put there, for all I know, to question the president's cognitive ability. I don't know why he put that in. But the fact is, there are going to be two debates, and the public will be able to judge the president's cognitive ability, and for that matter, the former president's cognitive abilities. There's no point debating it here.
Okay, and I'm not trying to bring this into a larger debate, but we're totally focused here. If we're talking about the privilege issue and whether or not they have a privilege, I believe they have waived that by providing the transcript, number one. Number two, when the report, now you can say it's not controlling or not, but the report does talk about his demeanor. It would be nice to see the tape so we could assess the demeanor ourselves. And again, I would say the privilege has been waived because you handed over the executive branch, not you specifically, but the executive branch has handed over the transcript. I mean, that's just my read of the situation. Mr. Russ, Chairman Comer is trying to talk too, so I will give you time, I promise. Chairman.
I just wanted to say this again. I mentioned in my opening statement, our timeline doesn't match up with the White House's narrative of their timeline of the discovery of the document. And one of the things the White House is obstructing is our ability to interview several of the White House employees about the specifics of when those mishandled classified documents were discovered. I just want to point that out.
Yeah, thanks, Mr. Chairman. Mr. Raskin, and then we'll go to Ms. Hageman. Mr.
Thank you,
Raskin.
Mr. Reschnitz. It's really more a question for you, because you make an interesting point. You assert that whatever privilege the president had, and obviously that was something that was expansively invoked by Donald Trump, but you're saying if he had an executive privilege, it was waived when he turned over the written transcript. But does that argument depend on the written transcript being a faithful transcription of the oral statements? If so, it would seem to defeat the point. I mean, let's say if they're really different, then he's asserting executive privilege, presumably, for the 0.001% of it that hasn't been turned over yet, right?
So I get what you're saying, but I would say that if the transcript is different, that's all the more reason to get the audio or the audio visual of it so we can see if the transcript meets the audio visual. But the fact, are you implying that the transcript was doctored?
No, but that's the paranoid theory that's been floated today by some people. But no, I think that's ridiculous. In other words, I think those two arguments cut against each other. The idea that the privilege has been waived depends on the idea that the written transcript is actually a faithful record of what was spoken. And I haven't seen any evidence, certainly, that there's any difference in the two. So, I think we are really splitting hairs here. I mean, it's kind of an amazing thing that we would think about holding the Attorney General of the United States in contempt for not giving the audio version when we have all these people walking around who've never given any testimony at all in answer to subpoenas, and it doesn't seem to trouble, at least your side of the aisle.
No, I get your argument, but I mean, again, if you've already handed over the transcript itself, I would still argue that you've already waived the privilege of then holding on to the audio visual of the transcript. I mean, that's just my understanding. I understand you're saying we're splitting hairs here, but Ms. Hageman?
Yes, a couple of things. To conflate the outcome of the two cases between Hunter Biden and President Trump is an absolute absurdity. It's also an absurdity to claim that the outcome in one case with Hunter Biden being convicted today is reflective of the viability or legality of what happened in New York is also absolutely absurd. So I wanted to I wanted to point that out.
Can you explain
to say
why?
That these two, I think that the facts are very clear in the record in terms of the differences between the two cases. And
To
how
the
they
juries, it
handled
was very
and the
clear.
legal- and the legal basis for
Yeah,
it.
and in both cases,
asking about the privilege and waiver. And it seems as though my colleagues on the other side believe that a privilege or a waiver is based upon a word-by-word basis, and the extent to which they may have waived any kind of a claim of privilege for the words that were included in the transcript, they would still be able to claim a privilege for the words that were left out, and that's what we're trying to get to with the audio, is also a legal absurdity. That is not the way that privilege or waiver either one work. What it is when you waive the subject matter, then you waive the subject matter. You have waived your ability to claim a privilege for those issues. You're not able to use privilege as both a sword and a shield and say, well, I'm going to release these 4 words, but I'm not going to release these 16 words. These 16 words are privileged, but these 4 words I will give to you, and there's a waiver. What a court would rule in that regard is, to the extent the 16 words relate to the 4 words, it's a waiver of the entire thing, because they're not going to allow you to use privilege as both a sword and a shield, which is what my colleagues on the other side seem to imply. I'd like to read 3 quotes from the Her report that put the issue that you have raised, Mr. Reschenthaler, front and center here about Mr. Biden's cognitive abilities and why the audio is so critically important. Quote, Mr. Biden's memory was significantly limited both during his recorded interviews with the ghostwriter in 2017 and in his interview with our office in 2023. That's on page 5, I believe. Quote, we have also considered that at trial, Mr. Biden would likely present himself to a jury, as he did during our interview with him, as a sympathetic, well-meaning elderly man with a poor memory. That is on page 6. Similar quote on page 219 of the report. And finally, Mr. Biden's memory also appeared to have significant limitations, both at the time he spoke to Zwanitzer in 2017, as evidenced by their recorded conversations, and today as evidenced by his recorded interview with our office. That's at page 207. I'd like to bring this back to actually what the purpose of this hearing is, which is our oversight responsibilities, both as the Judiciary Committee as well as the Oversight Committee. That's what this is all about. And I would say it's very obvious that the point of the other side is to deflect attention. They want to deflect attention from the fact that Joe Biden had unlawfully kept classified materials and shared them with his ghostwriter, for example. They want to deflect attention from the fact that clearly the audio and the written transcript are different, and that those differences might be incredibly significant in terms of our oversight responsibilities. It's clear under the Constitution, it's clear under the case law, that judiciary and oversight have the authority to obtain information such as this in carrying out our responsibilities as the legislative branch. That is really the only issue that is before this committee today. All this other nonsense, all this other noise, all these other words that are being thrown against the wall are entirely irrelevant as to whether we're entitled to this information, and if so, by withholding it, should Merrick Garland be held in contempt of Congress? And the fact is that he should, because there is no executive privilege. Even regardless of the transcript, there is no executive privilege for the information we're seeking, number one. And number two, if there was, it has been waived, and we're entitled to receive the information, the audio that we have requested. With that, I yield back.
Thanks, Ms. Hageman. Mr. Nadler?
I want to point out that the Her report, contrary to the insinuations of the gentlelady from Wyoming, repeatedly states that he did not indict Biden because the evidence of a crime just did not exist. Some sample quotes on page 4 of the Her report. Quote, we do not believe evidence is sufficient to indict, unquote. Page 6, there are, quote, innocent explanations, unquote, as to why Biden retained classified documents. Page 8, we do not, however, believe this evidence would meet the government's burden at trial, close quote. As I said before, that is why the special prosecutor declined to indict President Biden, as he states here, and that is why any reference to the president's alleged cognitive ability is gratuitous, because there's really nothing to do with this. I would like, however, to the gentlelady from Wyoming a moment ago said that there were clear differences between the way the Hunter Biden trial was conducted, and the legitimacy of that trial, and the illegitimacy of the Donald Trump trial in New York. Maybe she'd enlighten us as to the difference?
Ms.
I'd
Hagman?
be happy to, but I do not understand why that would be at all relevant to the
Because you brought
discussion
it up.
that we're having today. But I'm happy to have that debate
Please.
with you any day of the week.
Please.
But I just don't think that that's relevant to what we're discussing.
brought it up, so
I mean,
why
we
don't
can,
you
we
explain
can
it?
start with the
You said it was
judge. The
absurd.
judge-
Wait, hold on, Ms.
All
Ms.
right,
Hagman.
we can start with the judge that was handpicked rather than randomly chosen, which is typical in most of your court cases. You can talk about the fact that you talked about unanimity of verdict. We don't even know what the verdict was at this point in terms of what he was allegedly convicted of unanimously. We can talk about the fact that almost every single ruling that was made by Judge Mershon in New York was against the defense, despite the fact that when you're dealing with a criminal case, there's either typically much more of a balance, or in fact to ensure that the prosecution actually meets its burden of proving beyond a reasonable doubt, most of the rulings would be in favor of the criminal defendant, not in favor of the prosecution. It's in the fact that the expert witness, who is the former head of the Federal Election Commission, was excluded from testifying as an expert witness in the case in New York, despite the fact that he has been qualified as an expert witness to testify on these matters throughout the entire United States. It is the fact that there were other witnesses that were excluded. There was substantial evidence, prejudicial evidence, that was admitted during the course of the trial. And then when you look at what happened with Hunter Biden, the prosecution was very precise, very specific about the nature of the statute that was at issue and how he violated it. And then they brought in the evidence from the family members, the ex-wife, the girlfriend, the Beau's widow, the young girlfriend, all of the testimony, him reading the book, all of the testimony. The evidence was overwhelming that Hunter Biden had violated the specific statute at issue. So there's dramatic differences in terms of how the New York case was handled versus how the case against Hunter Biden was handled. If you'd like to spend another 3 or 4 hours, we can go outside and I can give you additional evidence to that effect.
All right, I just want to refocus. So I started the line of questions with this. It looks like I'm going to end it with this. I really think we've got to refocus everything on the one question that's before us, and that is, can the executive branch defy a subpoena that is lawfully issued and is also valid? I would make the argument that the answer to that is no, and I think that's the one issue. But the chairman has been incredibly generous with his time to me, so I'm going to go ahead and yield back. But I'd like to thank all the witnesses for being here.
Gentleman yields back. Chair thanks. The gentleman, the gentlelady from Pennsylvania is recognized for questions.
Thank you. We've covered a lot of ground and very little of it relevant to the question before the Rules Committee today, or the question that was presented so spectacularly to Oversight and Judiciary a couple of weeks back. We've had a year and a half of investigations, depositions, written testimony, hundreds of thousands of pages of documents, and House Republicans have not turned up any evidence of wrongdoing by the president or his associates. And it's quite a contrast. I mean, there are no impeachable offenses by a man who has lived his entire adult life in the glare of public life. It's been decades. And of course, this is a marked contrast to the former president, who spent decades shirking the law and his tax obligations with shady real estate deals, and whose criminal conduct became glaringly apparent when he stepped out of those shadows, and his lack of respect for the rule of law and for constitutional norms. And it is that contrast and its political implications that seem to have brought us here today. We've seen over the last year and a half, we've seen one conspiracy theory after another get shot down or evaporate when it was exposed to the light of day. But our Republican colleagues have doubled down on those theories, including some pretty spectacular ones today, wasting the time and money of 3 separate congressional committees on a wild goose chase that has not turned up anything. So after all these failures, they've manufactured this crazy controversy to try to kick around the Attorney General and to justify this baseless contempt resolution. It's another desperate attempt to save face after, if it weren't so sad, it would be ridiculous, but after a failed investigation, there is no crime, there is no wrongdoing, there are no impeachable offenses, but it's an election year. And as some of our colleagues on this committee have said, Republican majority hasn't accomplished anything. So here we are, there's no legitimate legislative purpose for forcing the DOJ to turn over audio tapes of its interviews with President Biden. It has the transcript, which was certified by the Trump appointee special counsel as being a true and accurate transcript of those interviews, although we're now hearing today some suggestion that somehow it's not. So it's painfully obvious, especially given some of the doctoring that we saw just this weekend of presidential remarks and videos and such. This is to distract. This is to distort. This is to push out more lies. And the repetition of the lies doesn't make them any less untrue. So it's a waste of congressional time. It's a waste of taxpayer dollars to continue pushing these charades. Representative Raskin, we just heard some pretty spectacular statements about this push to hold the Attorney General in contempt being a matter of oversight, although it's allegedly with respect to this crazy impeachment effort. Do you have any comment?
Well, I'm sorry my friend Mr. Reschenthaler is not here because I take him to be a really serious lawyer. And his assertion is that we can hold, or we should hold, in contempt any Attorney General or President of the United States, for that matter, or cabinet member who withholds any document. I just want to know, both retroactively with respect to the more than 100 investigations where Donald Trump stonewalled Congress, whether he believes that contempt properly was in play there, and he would have supported contempt against President Trump, and whether he would support contempt in the future against any president who has a disagreement. You know, a lot of these are substantive arguments being made about executive privilege, but of course, presidents, White Houses of both Democratic and Republican prominence assert executive privilege all the time. Should we be holding the president in contempt every time there's a disagreement over executive privilege? Of course, Donald Trump did it in the Mazars case, and he lost that case when we finally went to the Supreme Court. We didn't hold him in contempt in the meantime. We're still trying to get documents that we were granted under the Mazars case. This would be a great opportunity for Mr. Chairman, who's a newfound champion of transparency and light and disclosure, to announce today that he will turn over all of the documents that he's cooperated with Trump's lawyers in suppressing from Mazars. And I wonder whether he would feel at this point all of those Mazars documents should be turned over. And this is not a joke. This is for real stuff. And why does it have to be a partisan question? So there might be some interesting issues raised in court about the difference between a written or an audio transcript. I'm not convinced by what they're saying, but I do think it is truly absurd to say it rises to the level of holding the Attorney General of the United States in contempt when they were defending a president who blocked more than 100 different investigations, including an impeachment investigation, which is perhaps the most serious power we wield, because that's how we control presidents who engage in high crimes and misdemeanors and corrupt attacks on the U.S. Constitution.
Well, and yeah, and as famously as we know, that impeachment in part hinged upon the fact that the then president refused to answer questions, refused to show up and cooperate.
Well, it's like in his case, both I'm struck by Ms. Hageman's remarks because I'm actually amazed at the similarities between these two cases. Both Joe Biden, both Hunter Biden and Donald Trump were given the presumption of innocence. Both were given a jury trial. Both had a right to counsel, which they exercised by paying for exceptional private counsel. Both of them had a right to testify. Neither of them chose to testify, including Donald Trump, who now wants to testify to the world about how the fix was in and it was rigged and all that stuff, but he wasn't willing to get up on the stand and testify about why he didn't do it. No, he didn't want to do that. Fair enough, he exercised his constitutional right. Both of them had a right to a jury trial, and both of them had a right to a unanimous verdict. And in both cases, the jury unanimously found, in Trump's case, that he was guilty on 34 different counts, and in Hunter Biden's case, that he was guilty on 3 different counts. Now, Ms. Hagman made a series of what are essentially appellate arguments. For example, she says that this or that witness should have been allowed to testify beyond the domain that the judge allowed him to testify. For example, Brad Smith was allowed to testify within a certain range, but not on irrelevant things. Now, she says, it should have been the full 100 yards of the football field and not the 20 yards that he was allowed to testify on. Great, that's an appellate argument. Ms. Hagman sounds like an excellent criminal defense appeals lawyer, but is it grounds for attacking the rule of law in America and the system of justice in New York, much less the federal system of justice, which had nothing to do with it? And they're deliberately confusing people about that. Hunter Biden was prosecuted by federal prosecutors in federal court. Donald Trump was prosecuted in that particular case in state court by state prosecutors. I thought state law and the federalist system was something they supported, but apparently not. Not if it goes against Donald Trump. They're willing to just throw the whole thing out the window. But those are just appellate arguments, and Donald Trump, as far as I know, is going to exercise his right to appeal. So I'm happy, to go outside with you, Ms. Hagman, and you can give me 3 hours of description of what the appellate arguments are going to be, but ultimately an appellate court is going to sort it out. I'm a little bit more interested in just the rule of law and in justice. I'll quote a former colleague of ours, Liz Cheney, who was the head of the Republican conference, and she said, "At this moment, we're confronting a domestic threat that we've never faced before. That is a former president who's attempting to unravel the very foundations of our constitutional republic." I don't know if you guys remember Liz Cheney, but she said, "Republicans cannot both be loyal to Donald Trump and loyal to the Constitution at the same time," she said. So that's in honor of a very distinguished Republican colleague, former colleague of ours.
Thank you, Mr. Raskin. You raised some interesting points. I mean, this whole process here, the 3 committees, the relentless search for nothing, apparently, really has smacked of political theater. And you raised the point that, if this is about oversight and enforcing congressional subpoenas, how can it not be a partisan effort when they dropped enforcement of the subpoenas for Jim Jordan, for a host of people who allegedly conspired with the president to try to subvert the election results on January 6th.
Yeah.
I mean, they've dropped all of that enforcement.
We don't have to be naive about partisanship. Partisanship is built into our constitutional system. It's an expression of constitutional health that people have a right to participate, to form political parties, to, express themselves in that way. On behalf of our colleagues, they would probably say that Jim Jordan and Scott Perry and Andy Biggs and so on, that they had whatever legal arguments they wanted to raise against being subpoenaed there, okay? But so does the Attorney General of the United States. So they would have opposed a contempt motion against Jim Jordan or Andy Biggs or Mo Brooks or Kevin McCarthy. But why would they support a contempt motion when there's a reasonable difference of view about whether an audio tape and a transcript serve the same function, especially when this Attorney General and his administration have gone way beyond whatever any of our GOP colleagues did in terms of complying with a subpoena, and way beyond whatever Donald Trump ever did in terms of complying with the subpoena. So we all are partisans here. We don't have to play make-believe about that, but we at least should try to adhere to some basic principles as opposed to just turn on and turn off our principles according to whether it's going to affect the Democrats or the Republicans.
Thank you. I think at this point, I'd yield back. Thank you.
Gentlelady yields back chair. Thanks, the gentlelady. The gentlelady from Minnesota is recognized for questions.
Thank you, Mr. Chair. And I also am interested in the rule of law. And I have Chairman Comer, was the subpoena duly issued?
Yes, ma'am. Yes, ma'am.
Did Attorney General Garland ignore that?
Yes.
So that's what we're talking about today.
Yes, ma'am.
That should be our laser focus.
That's why I'm here.
And I appreciate that. Because I think if you're tuning in for bits and pieces of this, you miss the whole point that we have one thing in front of us. And I will tell you, I was interested when when I came in, and Mr. McGovern said this is a waste of time. But I remember sitting on that side of the desk, and 3 or 4 times we had rules like this holding someone in contempt, and so I appreciate.
Mr. Schwab.
I was not going to ask any more questions. I just wanted to make a statement.
Can I comment?
Certainly.
Thank you. The President has exerted executive privilege in this case, and the proper means is to contest the validity of the executive privilege in court, not to pursue a contempt against the Attorney General or anyone else. When executive privilege is asserted, it may be valid, it may not, that's up to a court.
Well, I find this incredibly just ridiculous because they have the transcript. All they are asking for is the videotape, and you're defending somehow that this videotape is then protected by executive priwilege.
That's a
It seems
perfectly
ridiculous.
that's an interesting argument for the court.
Okay, but it seems ridiculous that we are at a point here where that the videotape is not just released, and we have the transcript, and surprising that it didn't come together, that they weren't, in many cases. But I just wanted to make the statement that we need to focus on what we are talking about here so that the American people understand, and I know there's lots of talking points and there's all kinds of things, the American people need to understand this is about a duly issued subpoena that was ignored, and that is what we are talking about today.
Excuse me, it
And
was
with
not
that, I
ignored,
yield
it's
back.
executive privilege was asserted.
With compliance.
And I yield back.
Sure, thanks, gentlelady. Gentlelady yields back. The gentleman from South Carolina is recognized.
You know, I've sat here for what, 2 hours, probably going to be 3 or 4, and listen to these smoke screens that my friends on the other side of the aisle are saying. They bring up the trial of Donald Trump, convicted felon. Really? By a judge that is a known anti-Trumper? You bring out
jury, not by a judge.
Ms. Nadler, I've got the floor. If you're going to interrupt, Mr. Chairman, call him down when he interrupts. It's my time, and I'll let you respond, but I'm tired of this. You talk over everybody. It's so rude of you. But look, you bring up the smokescreen of Hunter Biden. I think we're here to talk about a video. Hunter Biden, it is kind of, strange. A gun charge? What about the fake LLCs that he's gotten money from China? What about the millions he got in paintings? We don't know who contributed to him. What about, you can name a lot of other charges, but we're not talking about that. And I'm tired of these smoke screens. You're talking about miscarriage of justice. It really is. And Ms. Hagerman, you bring up a very good point, the fact that we're to trust what they say, that the transcript is real, and the audio has no bearing on it. I don't understand. As our chairman said, they're putting up a fight to prevent the American people from hearing the video and using these lame excuses about altering, that Jordan altered some tape somewhere. I don't know how you alter a audio tape. Can you tell me who has got the audio tape? And I think the chairman had a valid point. Do they still exist? This administration is lawless when it comes to obeying the law.
What I can say is that the information was gathered by Mr. Herr being the investigator in this through the Department of Justice. And that's why the action has been brought against Merrick Garland, because Merrick Garland is the one that has the audio tape, is my understanding. Now, I could be corrected on that, but that has been my assumption, because he was the person who appointed Mr. Herr to conduct this investigation, and I believe that the report was directed to him. So that has been my assumption throughout this, that they would have the audio tape, and they've released the transcript.
So if he doesn't have it, or if he's destroyed it, that's a serious, or if they alter it or omit or whatever they do with it. But are you comfortable? I mean, you or Mr. Comer, do y'all feel the tape still exists? Because they're going to a big extreme to defer and try to prevent the American people from hearing it.
Well, all I can say on their behalf is I sure hope so.
Mr. Comer, Ms. Nadler, I'll get to you. Let me just,
It's my hope, and it's my understanding that they still exist. Hopefully, they didn't disappear like the cocaine at the White House. Hopefully, they're still in existence and haven't been destroyed.
Ms. Nadler, you want to, in a quick way, respond to it?
There is no reason to believe that the tapes don't still exist. I would point out again that the President has asserted executive privilege, and the proper forum for disputing the executive privilege is in court, not by a contempt citation. Once the President asserted executive privilege, it's not up to the Attorney General, Mr. Garland, to present the tape or not. It's up to whoever wants the tape, in this case the committee, to go to court and contest the executive privilege. I'd also want to point out on a separate matter that Ms. Hagman brought up, that Hunter Biden was tried and convicted by a jury of his peers.
It's not about Hunter Biden.
Well,
This is about the
and
tape, Ms. Nadler.
and she brought up a number of things, and that the president, or the former president, was convicted by a jury of his peers, and the questions she brings, and by the way, he made evidentiary rulings for the defense and against the defense. And whether his evidentiary rulings were correct, whether his decision to exclude certain witnesses was correct, will be decided on appeal in the appellate division or maybe in the Court of Appeals of the State of New York, and it's perfectly legitimate to question that, but it's not legitimate to question the legitimacy of the trial because those questions are appellate questions and will be answered by the appellate court.
Well, it didn't work with Richard Nixon. Once it was out, the transcript was out, he couldn't claim executive privilege. But I guess that's why the major news outlets are suing, to get something that you're trying to hide that you don't want the American people to see. It's really an insult to the American people that you're going to these links, having all these words about all these other trials that have nothing to do with this. Let me run down the timeline, and this is something I don't understand. Chairman Mr. Comer, you on February 12th, you sent a letter requesting all the documents and communications, including the videos, including the autos. On February 16th, the DOJ responded to you stating that they were being gathered. On February 27th, the Judiciary and Oversight Committee issued identical subpoenas to Garland for relevant information about the transcripts and about the audio. The return date was March 7th, and then the DOJ produced an incomplete set of documents comprising only correspondence exchange, no audio. On March 9th, the committee notified the DOJ that its production was inadequate, and as an accommodation, you offered to extend the date of production for the audio to March 11th at 3 o'clock. On March 11th, the DOJ informed the committee that documents were undergoing review by the agency, interagency, and they would not meet the committee's deadline. Why is he getting extension after extension? I don't think Steve Bannon got that. I don't think Peter Navarro got that.
And I think you've demonstrated factually the great lengths we've gone to try to work with them to help them comply. It shouldn't take any time, but we've gone to great lengths. We've gone above and beyond to make it as convenient as possible for them to turn over those tapes which we lawfully subpoenaed.
And then on April 15th, the committee did respond, just said they were not going to produce them. Didn't have to. That is such what are the consequences? What do you think? And I think we will vote this out of committee, and I hope the House will pass this. What's the consequences for Garland doing this? Will he be going to jail, or will he get off?
We've seen Merrick Garland has held others accountable for being held in contempt of Congress. So we'll see what happens. He has set a precedent. Merrick Garland set a precedent of going after people who Congress has held in contempt for not complying with subpoenas.
It's just isn't that complicated. Audio doesn't lie. Audio, he either said it, and they're going to these links to smokescreen everything else to try to prevent this to delay. Real quickly,
I just want to point out, when you talk about the smokescreen, that the senior-most career official at DOJ, a fellow named Brad Weinsheimer, submitted a declaration stating that he listened to every word of the audio files and, quote, the interview transcripts are accurate transcriptions of the words of the interview contained in the audio recording. That's on paragraph 14 of the Weinsheimer Declaration. So the allegation of the transcripts were altered in any way.
Mr. Adler, what's
is
that got to
absurd.
do with, what is that man's, his interpretation of the audio and the transcript, what's that got to do with anything? This is just releasing the tapes, let other people, why are all the news networks having to sue to get Garland to come?
As I said before, the reason that there is a hesitation about giving the audio to the Judiciary Committee is that the Judiciary Committee has previously altered audios to produce, in effect, fake versions of Ms.
We're not talking about that.
Well, we are talking about that because there is a fear that if the audio was given to the Judiciary Committee, Mr. Jordan or the people working for him, will alter that audio as they did for Ms. Jankowicz's audio and produce inaccurate audios.
Ms. Hagan, can you respond to that?
Sure, that accusation is untrue.
Well, thank you for bringing this. This is an embarrassment, to be honest with you. This is an embarrassment with what they're doing. I yield back, Mr. Chairman.
Chair thanks the gentleman. Gentleman yields back. The gentleman from Kentucky is recognized.
Representative Hageman, did you have anything you wanted to add to the testimony here, or anything you want to respond to?
No, I think that we've pretty much covered the issues that are relevant and then some.
Chairman Comer, do you have anything else to add?
No, I think that, we're here for the purpose of holding the Attorney General in contempt for not complying with a lawful subpoena. And I think it's pretty cut and dry.
Thank you. I have no questions then.
Chair thanks the gentleman. Gentleman yields back. The gentleman from Georgia is recognized for questions.
Thank you, Mr. Chairman. I go back to what Ms. Fishbach said in her question. Were the subpoenas legal? Were they legally authorized?
Yes, sir.
Were they complied with?
No, sir.
There are no other questions to me. And so I would suggest that before the vote is put on the floor, that Merrick Garland, if he complies with the subpoenas, then we not push forward with the vote at that stage. But I want to say this about how disingenuous it is of people who have been to law school admitted by a bar, I assume, to say that a conviction in a state court is the same as a conviction in a federal court. If Donald Trump's jury pool had come from the Southern District of New York, where the jury pool would have been from 8 counties, I would suggest to you that he would have had a jury pool where he would have had a chance. But that man, when in Manhattan, that put him before that jury pool, knew that Donald Trump was not going to get a chance. That any honorable prosecutor would have allowed that case to be moved to a venue where the person would have had a fair shot. So I don't know, Mr. Nadler, I'm not, I listen to you make excuses. I listen to you say, well, the reason, let me see, what was it you said? The reason to withhold is that it might be, someone might change it. Well, they might not want to release the thing. I'm not aware of the person who's being subpoenaed having the choice to comply or not to comply with the subpoena. Okay, Mr. Nadler, do you have a choice? Well, I want you to answer this question. If you were subpoenaed, do you have a choice not to comply with the subpoena?
You do not, unless the president has asserted executive privilege, and then it's got to be decided in court. What I wanted to comment on was what you said about the trial in New York. The trial was conducted by a New York County prosecutor in New York County because it was a violation of state law, not federal law. Now, he may have violated federal law too, but that was
But I'll reclaim my time, but the two of you on the Democratic side have acted as if that conviction in a very limited jury pool would be the same as conviction. If it had been in a federal court, the jury pool would have been pulled from 8 counties in that. Would you at least agree with me that if it had been in federal, it would have been 8 counties?
Yes, I would
Okay,
simply
and would you
observe-
agree with me, there's a difference in pulling from a jury pool of 8 counties and pulling from one that, you know, even.
I would simply point out that the defense had every opportunity to exercise its challenges in the voir dire, and that the 12 jurors who were picked were ultimately agreed upon by the defense and the prosecution.
That's, you know as well as I do that that's a, when you're agreeing to something from bad to worse, you know, I mean, President Trump didn't have a chance with that jury pool. And the bottom line is this: he's going to be President Trump again,
Maybe.
and that's why y'all are so scared of him, and that's why y'all are going to great lengths. I personally, Mr. Chairman, I don't think we need the audio tape. I think every time Joe Biden goes on TV, we see what Mr. Herr concluded. He's a well-meaning elderly man that probably doesn't have his wits about him, and with that, I'll yield back.
He's not talking about sharks and electric
Chair, thanks,
boats.
the gentleman.
I'm sorry, I didn't hear that. What was that, Mr. McGovern?
He's not talking about sharks and electric boats.
I don't think he knows what he's talking about.
That was Trump, by the way.
Seeing no further members wishing to ask questions, I want to thank this panel. Mr. Raskin, I always feel like I should put in for continuing legal education every time you come and testify.
Credit granted, credit granted.
We miss you up here, and witnesses are excused.
Yeah, I gotta finish on that.
You have the latest.
So it's custom of the committee to bring forward 6 members at a time to expedite testimony. So I'm going to ask Mr. Carter, Mr. Grothman, Dr. Wenstrup, Burgess Owens, and Rich McCormick